about?
Yep.
Okay. All right. Let's bring the jury in.
Oh, it's on, people. It's on.
Be seated. Good morning, folks. Hope everybody had a nice evening, and thank you for all coming back. We appreciate it. When you enter the courtroom, you're going to find the parties standing. They're standing out of respect for the role that jurors play in our judicial system. So when you come in, you feel free to just go ahead and have a seat. All right, folks, you have been previously instructed. Those instructions that I gave you yesterday obviously apply today during our trial proceedings. We will begin with opening statements. Mr. Sharp.
Thank you, Your Honor.
Morning, everybody. Looks like we all made it back. Thank you for that. Your time is precious, and I recognize that. I hope this trial will be fairly swiftly so you can get back to your lives. Should be a fairly simple affair. I'd like to get out in front of it and point out that I would imagine it can be difficult to sit on a jury. If you feel that you are being asked to pass judgment on it, where one way or another, whether that's a good person. And I just want to make sure that everybody understands that's not what we're discussing today. You're not going to see the city come out and present a parade of horribles and say, jury, now that you have seen all of this, make your decision. Is Mr. Milton good or bad? That's not what we're doing. I would like to think, as I imagine all of us in this room, we're here today specifically to examine and okay. We are asking you to decide whether Mr. Milton took certain actions that he's been accused of and whether those actions violate the law. It's that simple. In the city's case, it's as simple as 1, 2, 3. Evidence will show, I believe, that 1, it was made very clear to Mr. Milton that he wasn't welcome back in that 7-Eleven store, and he knew it. 2, that he went back in there anyway. And 3, this happened in Lacey on March 31st, 2020. City intends to prove this by presenting evidence in the form of testimony from 2 witnesses and 1 physical exhibit that you'll be able to look at. The testimony will present an event that happened in 2 phases on March 31st. I'll call this the early contact phase and the late contact phase. What I'm offering you right now is just a rough preview of what I expect the evidence is going to show to you, so you have a roadmap. You kind of know where we're going and what to expect, and have a framework to receive this information. So obviously you will hear from Officer Evers. I wonder if you assume that that is the case. You'll also hear from one other witness today. It's a civilian. Yes, she was a clerk at the 7-Eleven store that day on March 31st. She'll take the stand first. She'll start by describing that early contact phase of this incident. She'll explain to you how it was a busy Friday afternoon at that 7-Eleven gas station, and that Mr. Milton had been at the store that day. He was in and out that afternoon, not conducting typical business in the store there. She'll describe what could fairly be called a loitering behavior, that he was hassling staff and customers in the store. She'll describe that she believed he showed signs of being intoxicated, that he had expressed that he was too drunk to be held accountable. She'll describe how he brought a cell phone in, was trying to get back charged within the store. They had asked him to leave. She'd asked him to leave at the time, and he did. And she'll explain, I feel protected. She felt of severe. That after a while, and not bleeding when he asked, she called the police. At that point, we'll move roughly to the later contact. You got to hear from Miss Heasley all in one go, and then you hear from Officer Beavers. So they both have two contacts to explain, and the chronology will be a little tricky there because it's all Miss Heasley and it's all Miss Beavers. I hope you can track it. I don't think you can. Miss Heasley will explain that after the police came and warned Mr. Milton not to go back in the store, that she kept herself busy to try to stay away from the front counter in case he did come back. She would feel safe. So explain she kept an eye on things and sure enough to explain Mr. Milton did. I'll leave it to her to explain what she saw and heard when that happened. And I'd suggest maybe trying your best to imagine what it must have been like in that store. What the environment was like, how you would have felt when you were a customer. She'll also explain that that second time coming in, that Mr. Milton also brought his cell phone that time. So both of these contacts should explain the phone and cell phone. Officer Hughes will take the stand after Ms. Heasley. She will explain to you how she was dispatched there after a call to the police. She arrived and received a complaint from Ms. Heasley. This is the first contact. Besides receiving the complaint, she also received the cell phone. That's pretty important. She'll describe that for you. She'll describe to you how she gave Mr. Milton, the verbal warning, hey, you can't go in there. She'll describe the written warnings that she gave you. We'll go through this, and you'll be able to see this. She'll describe to you the conversation that she had with Mr. Milton, her take on his intoxication. She'll explain how he asked if he could go back in to charge his phone, and she specifically told him no. Also explain how there was a tricky issue and his car was outside the store. She didn't want to drive in and save things. They worked out together, some troubleshooting to arrange for him to be able to push the car off into the next lot, so it wouldn't be 7-Eleven property. And then left. Unfortunately, I come back again a couple hours later and so this is a rough roadmap of what I expect you'll see from these two witnesses. I ask you to, while all of this is happening, use a tool that we all have, the same thing. It's built-in live. I call mine my baloney meter. When mine starts going off, I think I might be fed a bologna sandwich. Whatever you want to call yours, I'd ask you just kind of be sensitive to that phase. The witnesses all testify. You are the ultimate arbitrators of credibility. So who should you believe? That's up to you. So that's the tool you decide. Central in this case is going to be whether Mr. Milton was, as he claimed to be, too drunk to be held accountable. I'd suggest that you pay attention, especially during Officer Beaver's testimony, as she describes her training and experience in dealing with people who've been using alcohol, as well as her observations of Mr. Milton in that particular encounter. How the conversations go, listen to how she describes how they were coherent or not, how complex they were or not, how responsive Mr. Milton was, and whether those are indicators that he's maybe too drunk to be held accountable or in the city's case is as simple as 1, 2, 3. I believe the evidence will show beyond a reasonable doubt in the city's case that Mr. Milton did, in fact, no, it was made clear to him, would not go back into that 7-Eleven store. 2, did it anyway. 3, this happened in Lacey on March 31st. Conclusion of the trial toward the very end, the judge will read to you the jury instructions. There's a packet that you'll get to read along with it. And those are the judge's instructions as to what the law is. Once you receive those and he reads those to you, we'll have another chance to talk, and I'm going to take that opportunity to connect the facts from the testimony to the law that's in that package, show you how they line up, show what I believe is a clear case that the facts indicate a violation. I hope that you'll agree with me at the conclusion of that presentation on the facts.
Right.
Why is the city of Lacey?
This is a criminal. Thank you, Mr. Sharp. Mr. Milton? Got it.
Jerry
Oh, here we go.
was out of gas. Was hanging out with a friend. About 60 years old. Store. He and I were drinking together. Went in, and Jessica Heasley, I believe is the name, denied me a sale. But then the manager there was like, "Why are you treating him like that?" And everybody else here.
Your Honor,
thinks
objection.
that.
Okay.
I'm so sorry to interject, Your Honor.
Okay, Mr. Milton, hold on just a moment.
I would like to not be interrupted, but I will.
Okay.
I apologize for the interruption. The city has to object. Mr. Milton unfortunately is introducing testimony while not under oath rather than presenting an opening statement.
Okay, well, the juries understand what Mr. Milton is saying is what he believes the facts will show. Mr. Milton, go ahead.
Forgive me, Your Honor. I was out of gas. The manager told her that she's not allowed to deny me the sale because she's the only one that doesn't like me there. So she told me that I had to leave because she had a problem with me. I was intoxicated, like I just said. I left. I had no gas. She called the police on me.
No gas and wasted.
The manager came out. As soon as the police had left and said, "Here's $10, go get gas and get them out of here." I was never allowed to leave with my belongings, with all of my stuff. I went in to buy the gas, and then she called the police on me. The manager at the time had a plane to catch. So she gave me the $10 and went to go catch them. I denied the sale on gas. I got called on and I got arrested. When the police got there, I said, "Okay, Evers, I'm too drunk to tell you that I didn't do wrong right now, I guess."
Thank you, Mr. Milton. And Mr. Sheriff, if you call your first witness, please.
Thank you, Your Honor. The city calls Jessica Heasley and she's in the hallway.
All right.
Do you mind going to get her?
Yeah.
Thank you.
Well, that was craptacular. It really was. In addition to trespassing, I was probably driving drunk. I wanted to get that in there before we started this the testimony here. I don't know. Let me see.
Easily, if you'd step up here, please.
Doesn't look like it.
And raise your right hand for me. Swear the testimony in this case to be the truth, the whole truth, and nothing but the truth. You can just say yes.
Yes.
Okay, go ahead and have a seat.
Thank you. Good morning. Jessica Heasley. Jessica
And what do you do for a living?
I work as a store sales associate at 7-Eleven.
Which 7-Eleven?
The one on 2425 Marvin Road, Lacey.
And were you working on March 31st, 2013?
Yes, I was.
What happened that day?
A gentleman had come into the store while I was on the break in the back room, and started shouting. I asked him to leave. and my coworker also asked him to leave.
You're under oath. I object, Your Honor.
The nature of the objection.
The nature is, she's under oath and I was literally served after she mistreated me, so
Okay, yeah, a different view of the facts isn't a basis for an objection.
cool, it's not a different view of the facts, it is a fact, but
Okay,
thank you, Your Honor.
all right. You may proceed, Mr. Sharp.
Pick up where you were.
He was asked to leave. My coworker ended up being the one to kind of encourage him to go.
And what time was this from?
I believe after 2 p.m. I called the cops after he refused to leave, and he put himself in the doorway and claimed that since he was outside the store, he was gone and we couldn't tell him to leave.
I object again.
Okay, good. I'm not gonna hear that objection unless there is an objection.
She's under oath and she's lying.
Okay.
I don't
all right.
appreciate it.
Okay, thank you. Go ahead, Mr. Sharp.
Let's back up a little bit, if you don't mind. How are you feeling today?
Nervous.
Nervous? Feel free to pace yourself and take a breath as you need. So about 2 o'clock in the afternoon, you were at work. What did you see in here?
Initially I didn't see much. I was in the back room. I did hear him start to shout. I didn't hear a lot of it. I believe things about his personal life. He did start to insult me.
So,
He called me a heartless bitch. And asked my coworker if he said he hated that bitch yet today.
so what happened after you heard him say these things?
We asked him to leave. My coworker talked to him a little and said he couldn't be in here, be in the store drunk and shouting. And then he put himself in the doorway, like I said. I called the cops from the back room and told them there was a drunk man who was refusing to leave the premises and was insulting me. And that he left the store for a little bit, but in the time it took for the cops to arrive, he'd come in and out of the store a few times. I believe the second or third time came in, he claimed that it was his cell phone and asked us to charge it for him. My coworker plugged it into the outlet. He also attempted to purchase gas, and we refused the sale because we didn't think it was a good idea. One, to sell gas to someone who seemed to be drunk, and two, I informed him that we were not going to serve him because he was not supposed to be on the premises.
Ma'am, you mentioned a couple of times. Why do you?
He seemed very emotionally volatile. He was raising his voice a lot and seemed aggressive, and his hands were shaking a little, I think. He was a semi-regular, and I hadn't seen him act this way before. He'd come in before, and while he wasn't always an ideal customer, he did seem a lot calmer and wasn't prone to raising his voice. I'm sorry, I lost track of where I was.
So, I believe chronologically, it left off with his cell phone.
Yes, he claimed it. Sorry.
What happened?
He claimed it was his cell phone and asked us to charge it. I attempted to say no. My coworker just kind of went with it. The phone was on the charger charging until the cops arrived. I'm not entirely sure how many times he came in and out of the store. I mostly attempted to avoid the counter as long as he was there. So I went into the back for part of this, and then I found chores that kept me away from the counter because I was nervous about him being there.
Would you recognize that person?
Yes,
See that person present today?
right there.
Let the record reflect that it's pointed to the individual.
It will.
At one of the times he came inside while we were waiting for the cops, he claimed that he owned the Lacey police department and the court system, and nothing would come of calling the cops on him. And my coworker informed me that he was asking for me and had said that he was going to be outside all day. So if I would want to come to talk to him, he'd apparently just talk to me after work, which was kind of terrifying. The cops arrived. I'm not sure how much later. And I was not outside, so I don't know anything that happened between the cops and him. But they came to talk to me after.
I'm going to interrupt you. Mr. Sharp, if you'll ask questions rather than have a narrative, please.
Sure, Your Honor. Okay, ma'am, so, when the cops arrived, what did you?
I kept working. I was breaking down cardboard because it kept me away from the counter, but also let me watch the door. The cops came to talk to me. They gave me a yellow trespassing paper, which had his name on it and said that he acknowledged the trespassing.
Did you read that paper then?
Yes, I read it through and then I put it in our drawer where we put paperwork and things.
You may.
Yeah, I'm handing you what's been marked as plaintiff's exhibit 1. Take a look at that. Real quick. Recognize that one?
Yes, ours was yellow, but yes. It says, I, Peyton A. Milton, and born on August 3rd, 1993, do hereby acknowledge that I've been notified by J. Evers of 7-Eleven that from this day forward, I am prohibited from entering the premises located at 2425 Marvin Road, Northeast Lacey, Washington. It acknowledges that if he does, it could result in his arrest for criminal trespass in accordance with LMC 9.28.090. And then it says he has been advised and acknowledged that on the date of the 31st of March, he and then it also says,
That's okay.
yeah.
Thank you for reading that.
Sorry.
You may.
So is this the, well, I'll ask why you still have it. Is this the same form that you saw that day?
Yes.
Thank you.
Okay, so the police had arrived. They went outside with Mr. Milton. They came in, gave you this form, and what happened?
They told me that he still had a chance to vacate the premises if he came back in, to call them again and they would come arrest him, and that his car needed to be gone by end of day. And I gave them the cell phone from inside and said that he claimed it was his phone. And I wasn't comfortable going to return it to him. So I handed the cop the phone and asked them to return it. After the cops left, I'm not sure how much longer, but he came back in with the phone and tossed it on the counter and said that it wasn't his. I told
What
him,
happened then, so the police had left, came in. Inside, and what happened after that?
I told him he needed to leave because he had been trespassed, and if he did not leave, I was going to call the cops again. He did not leave, so I called the cops again.
How was he acting?
I think the best word would be belligerent. He was still very, did not seem inclined to listen when asked to leave. There was an argument with another customer. I missed the initial spark to the argument, so I don't know what led to it. But when I came out to see what was going on, he was not very, he was about 6 inches away from another customer. He was elderly, and he was shouting that he owned their community and he'd done so much for the community. They can't treat him like this.
Saying
Milton, Peyton. I asked him to leave again, and he was very focused on the argument. He barely acknowledged me. He would not stop arguing with this gentleman. At some point, he sat himself on the ground in his refusal to leave. It was honestly, we were like very focused on this as well. There was a line building up. The customer seemed pretty upset as well.
so after sat down on the ground, what was happening while he was seated? What was he doing?
Still arguing with this gentleman. At some point, we just tried to work around him. My coworker came, the one who had chased him out the first time, she had left and forgotten something at the store. So she came back and kind of chased him out again. When the cops came back, he was arrested. He was outside in the parking lot again by that point. He was arrested, and when the cops came to talk to me,
Where were you?
still inside the store, I was, I believe, breaking down cardboard again. When the cops came to talk to me to tell me they're arresting him, I got the phone he put on the counter and gave it to her, and said that he said,
If you'll stop right there. Sure.
Your Honor, that the record, or city asked the record indicate that Ms. Easley pointed to Officer Beavers at the city's table.
I'm sorry, I forgot her name,
It will.
and said that he claimed it was not his cell phone. And at that point, he was arrested. He was off the premises. And she kind of gave me the rundown of, you shouldn't deal with this again. If you ever do see him on the premises again, call us again. You still have the trespassing paperwork. And that was kind of the end of it.
Thank you. Further questions at this time?
All right, thank you. Mr. Milton, do you have questions for Ms. Easley?
I do, but I don't know what they would be at this current point in time, and I don't really like dealing with people that lie under oath.
Okay,
So I'll
you
just,
can't comment on her credibility. All you can do right now is ask questions.
no, I'm all right, Your Honor, is what I meant to say.
All right, thank you.
Well played.
Members of the jury, any questions for Ms. Easley?
Amazing cross.
See any objection, Ms. Easley being excused?
No, that would be the request, John.
And Mr. Milton, any objection, Ms. Easley being excused?
I guess I do have one more question now that I think about it.
Okay, go ahead.
Should I
You
didn't
can
have
sit or you can do it from the easel.
Oh, here we
It's your
go.
Choice.
Do you remember who came to pick up the phone a week later?
No, I handed it to the police officer.
Okay. So you don't remember hearing about it being in storage or being in lost and found and somebody else coming to get it?
Nope, I handed it to the police officer.
Okay. And did you know that the man that you said that I was arguing with was my friend and trying to get me out of the store to help you?
No,
Because, forgive me, I'm only allowed to ask questions.
Correct.
Thank you, Your Honor.
All right, thank you, Mr. Mel. Anything else, Mr. Sharp?
No, Your Honor, thank you.
Well done.
Ms. Healy, your excuse. Thank you very much for your testimony.
thank you. Have a good day.
On cross, he adds that even his friend was telling him he's a jackwagon and needs to leave. Good job.
Next witness, please.
Your Honor, city calls Officer Evers to the stand.
Raise your right hand, please. Swear the testimony in this case will be the important of the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
You may have a seat.
Officer,
Morning.
please introduce yourself to the jury and state your or spell your name for the record.
Yes, Josie Evers, Josie, and last is Evers.
And you're in uniform, officer, police officer, where do you work?
I work for the city of Lacey as a commissioned police officer.
What are your duties there?
I work patrol, so I respond to calls of service on the road as a patrol officer.
Were you on duty on March 31st of this year?
Yes, I was.
Were you dispatched to the 7-Eleven store?
Yes.
What happened?
So at approximately 2 p.m., I was dispatched to an unwanted call at the 7-Eleven on Marvin Road. Dispatch advised that there was a male being belligerent and yelling at staff members. I responded to the area of the 7-Eleven. When I got to the 7-Eleven, I contacted Miss Heasley inside the store. Miss Heasley advised me that there was a white male. He was approximately 5'5" with a beard, and then he was wearing a plaid green and black long sleeve flannel. She advised me this male had come into the store, was yelling, being belligerent, disturbing the other customers inside the store. She also advised me at one point he had told her that he would be waiting outside when she got off of work. With that information, she also told me that he had a Toyota 4Runner that was parked on the side of the 7-Eleven building. She advised me right before I'd gotten there, he had left the store and gone into the 4Runner. With that information, I went outside the store and I looked over and I saw the 4Runner right where she had said it would be parked. And inside of that was Mr. Milton sitting in the driver's seat. Before contacting him, I already had contacted him on prior social contacts before, so I recognized him.
Awesome. Sorry to interrupt.
Yes.
So you had prior contacts with him, were you aware of his identity?
Yes, so as a patrol officer, I go on what we call social contacts, where I've seen him outside other gas stations and the 7-Eleven clean up trash, and I just went and talked to him. Offer him we have a mobile outreach team to see if he needed resources or if there's anything we could help him with. At that time, he also had provided me I asked for his name and he willingly gave me his name and his date of birth on that prior social contact. And with that, I ran him for any wants or warrants. And to confirm his identity, in our system, I pulled up his Department of Licensing photograph, which is how I was able to identify him.
People left off, you had just spoken with Ms. Heasley in the store and going out to contact Mr.
Yes, and then Miss Heasley also provided me with a cell phone, and she said he had left it inside of the store, a little prepaid phone with a charger. She told me the gentleman, Mr. Milton, had left it inside the store, and she didn't feel comfortable or safe giving it back to him. She also advised me she wanted him trespassed from the store, so she provided me the cell phone and the charger. So right where I left off, I went out to the Toyota 4Runner. I contacted Mr. Milton. I asked Mr. Milton if he was inside the store, and he stated that he was. I provided him the cell phone and the charger back. Speaking with him, based on my training experience, I could smell the odor of intoxicating liquor coming from his breath. I think there was also a beer can sitting in some portion of the vehicle. So
If I could interrupt. You
Yes.
also, To ask you questions here. You mentioned your training experience and then you
Yes.
recognize the odor of alcohol. Tell me very little bit about your training experience as far as it pertains to alcohol consumption.
Yes, so we go to CJTC, which is the Basic Law Enforcement Academy, where they teach us field sobriety testing, BAC testing, and then the indicators of when someone is intoxicated. So droopy eyes, obviously the odor of, and liquor on someone's breath. Droopy eyes, if they are slurring their words, how they're standing, the ability to walk. And so just being inside the academy, they taught us the basics. And then I've been a patrol officer for 1 year now, and I've just had multiple contacts, DUIs, and just social contacts with people who are intoxicated.
So you made contact with this plan with Mr. Bill.
Yes. So I provided him back his cell phone and the charger. He took the cell phone and the charger from me. So at this point, I asked him if he had been inside the store. He said he was. And then I tried to interact with him a little bit more, but he kept saying to me, "I'm too drunk to be held accountable for my actions." I tried, communicating him, getting his side of things, but he just kept telling me, "I'm too drunk to be held accountable for my actions." So at that point, I advised him, "You're going to be trespassed from the store. You're not going to be allowed back on the property." He asked me if he should move his car because it was parked right next to the building. And I advised him that because he had just said, and I could tell that he was drunk based on my experience. I didn't want him to drive, obviously. So I advised him, he asked if he could manually, him and his friend was sitting in the passenger seat, and they asked if they could get out and put it in neutral and push it. There's about 25 yards away, there's a little gravel spot next to the 7-Eleven that isn't really their property, and he asked if they could push it over there so that he wouldn't be driving. And I advised that's fine. I said he asked if he could move it tomorrow, and I said no, you have the end until nightfall to push the car, or until you're sober. If you're sober, you can drive it away. So I went back to my patrol vehicle, and I completed a trespass warning.
Also, I'm gonna,
Yes.
Your Honor, could I approach the witness?
Me.
So, Officer Evers, I'm handing you what's been marked as plaintiff's exhibit 1.
Yes.
You recognize that exhibit?
Yes, I do.
What is that?
So this is our City of Lacey trespass warning paperwork.
Ms. Heasley read this to the jury, so there are at least a substantial portion of its contents.
Mhm.
She mentioned on there that he acknowledged that. I wonder if you could describe to the jury what the form indicates as to that and why.
Yes. So I wrote his name, all of his information, because like I said, I had his information. I had attached it to the call as well. And I had already confirmed his identity. I wrote the date. Right here, it says signed. Normally, you would hand that to the person being trespassed, and you would ask them to sign their name. I, however, write acknowledged in front of them rather than having them sign it. If they're showing any signs that they're intoxicated or that they might possibly be disorderly, I prefer not to hand them a pen just because it could be used as a weapon against me. So I just, advise them in front of them, and then I write acknowledged. We also have here at the bottom where normally a manager or the person who requested they be trespassed would sign and then date. However, with the city of Lacey, we've worked with one of our units, a community resource unit. They went out to all the a few of the businesses in Lacey, and they basically asked them, hey, when it's nighttime and we have someone using narcotics on the property or being disorderly, can we basically have your authorization to trespass someone? So the management, all of this, it says on file because we have the manager's permission on our file that gives us the authorization to trespass someone for them.
So officer, after you
Yes.
filled out that form, what happened then?
So I completed the form. This form has 3 pages attached to one, and as you write on it, it leaks through each page. It has a white form. This white form is for us to keep for our records so we know who's been trespassed from what properties. It comes with a pink form, and that one is for the offender to give to them. And then a yellow form, which is what I later provided to Ms. Heasley. So I completed the form. I ripped off the pink sheet for Mr. Milton. And then I went back to Mr. Milton. At that point, he still had the cell phone and the charger in his hand. And he asked me, well, can I go back in and charge my phone? And I said, no, you're not allowed on the property. I said, here is the trespass warning. I provided him the pink slip of paper. And I said, if you go back in the store, you will be arrested. I said, because you're intoxicated, I'm not going to make you drive. And, if you're tired, you can rest in your car before you push it over to the other side of the lot. But if you enter, I told him, if you enter the store, if you go over to the gas stations, if you go outside on the walkway in front of the store or on their property, you're going to be arrested for trespass. And then I provided him the paper. He agreed that he would move his car later in the evening. And then I went back into the store. I advised Miss Heasley, hey, he's been trespassed. If he comes, I advise him not to come in the store. And I let her know, hey, he's intoxicated. I'm going to let him stay in his car out there for a little bit. But if he comes back in the store or is being belligerent, just call us and we'll come back. So I talked with her. She acknowledged, and then I left the property and I responded to other calls. At approximately 4:30 in the evening, we got another call from the Marvin Road, and Jessica Heasley was the one who had reported it to us.
Also, just for those not
Yes.
store there, how long was it roughly between these two?
So the first call was at approximately 2 p.m. and then the second call was approximately 4:30, so about 2.5 hours between.
You were dispatched. What happened?
Yes, so the call notes said that he had been disorderly in the store and he had went back inside. I responded back to the location and I went inside to contact Miss Heasley first. She advised me that he had come back into the store, that he was yelling at staff and he was being belligerent again. And then she again provided me the same prepaid phone that was left by him, Mr. Milton, prior. She provided it to me again. I took the cell phone. Actually, I believe I left the cell phone with her for now. And then I walked out of the store. I went over to Mr. Milton, who again was sitting in the driver's seat of the car at that point. I advised Mr. Milton, hey, I told you, don't go back into the store. You're going to be arrested. He just continued to tell me I'm too drunk to be held accountable for my actions. He kept, whenever I tried to communicate that with him, he kept saying that. I advised him, no, you're going to be under arrest for trespass. I opened the door of the vehicle. He was holding a drink and smoking a cigarette. And I was like, no, you're done. You need to sit down. It was some like Starbucks cup and then a cigarette. I said, no, you need to set that down. It's time to go. He complied. He was able to stand out of the vehicle and I placed him in the handcuffs. And he wasn't so intoxicated that he never requested like medical. He did not seem so impaired that I felt he was in danger to himself or that he was so intoxicated he didn't understand me. He was able to stand out of the vehicle, comply when I put handcuffs on him. When I walked him to my patrol car, he was able to walk with me, and I wasn't trying to carry him by any means because of his intoxication. And then I placed him in the patrol car. I went back inside the store and collected the cell phone from Miss Heasley. And I believe at that point I had asked Mr. Milton if he wanted to take the cell phone with him or if he wanted to leave it in the car. His friend who was in the Toyota, he asked if his friend could like have the keys to the car, and then he was transported to the Nisqually jail where he was booked for the LMC of trespass.
Also, I'd like to just ask a couple of clarifying questions, revisiting that issue of intoxication.
Mhm.
I received, Mr. Milton states, so you testified you had two different conversations with the applicant.
Yeah.
How do you describe those conversations in terms of parents?
He was, especially when I was speaking to him about moving his car, like he was, asking, hey, can I move it tomorrow? I was like, no. And then he asked me earlier, hey, can I go inside and charge my phone? No. If I tried to ask him questions and communicate with him, he would say, I'm too drunk to be held accountable for my actions. His words were slightly slurred, but it wasn't so much where I couldn't understand him or I felt he couldn't understand me. When I handed him the trespass form, he was able to physically grab it from my hand and collect it. So I didn't feel he needed medical attention or was too intoxicated where it was a danger to himself. So
Thank you, Officer. This time, say it's-
Thank you.
Come on,
Mr.
let's
Milton,
see it.
questions for Officer Evers?
Yes, Your Honor.
It's what we've been waiting for.
Evers. Officer Evers, do you recall that I was out of gas?
I believe you did tell me you were out. Yeah.
Okay. And that was why I was gonna have to push my car. Is that right?
I believe you told me that you were too intoxicated to drive, which is why you had to push your car.
Oh, okay. I probably would have said that to the officer. Do you recall that I had my friend contact me after I was placed in the back of your vehicle? And I believe you were up front finishing your report. And I was like, hey, your phone is still inside, dude. Go get it. By the way, can you please make sure my vehicle doesn't get stolen again?
Yes, I do remember you giving him the keys.
Okay.
I don't recall you saying anything about it being his cell phone.
Okay. You recall me asking Jessica if she knew whether or not who came and picked up that phone later. It was like 6 days later, I was released. My friend was like, where'd my phone go, dude?
I was not present for that. No.
Okay. That was actually earlier in the courtroom today.
Where'd my phone go, dude?
Oh,
Forgive me. Forgive me. I must not have been clear enough. I should have said that. When you guys, as police protocol is operating,
She
you guys
loved it.
investigate the narrative of the call or the antagonist of the situation? Narrative.
I think I'm trying to understand what you're asking me, but I believe we speak to everyone involved. Are you talking about a trespass or just
In general.
in general?
In general.
Well, if it's a criminal offense, we develop probable cause for a crime, and if we have probable cause that a crime occurred, then we make an arrest on it.
Gotcha.
That's what you're asking.
Okay. Questions do I need to ask you that I was going to ask myself until yesterday? You made contact with the manager? Jessica.
Miss Heasley, and there were other staff members present at that time.
How many other staff members were there?
I believe one other. There may have been two others. I don't recall completely, but Miss Heasley was my primary contact.
Gotcha, there was two. Wrap up
Mm.
was the manager who was just about to leave.
Make that a question.
Sure. Do you know the manager there at the 7-Eleven?
At the time, I did not know.
And you know that I am a regular there and I have permissions more or less to stay on the tribal truck stop across the street.
I did not have the information. No.
I wasn't aware of your regular status.
Um, if I was asked to leave and I was allowed to leave based on perhaps somebody stopping me from being all of my belongings, but I did my best to get out of there as quickly as possible, would I still be guilty of a trespass if the
Objection.
manager there told me to go get gas to leave?
Your Honor, objection. He's asking the witness to opine about final conclusion of law.
Yeah.
I'm going to change your question because you can't ask somebody, the jury's going to determine whether you're guilty or not. It's not up to Officer Evers. Okay, so what I'll lie to ask is, would Officer Evers arrest you given those facts?
There you go.
Well, I would, because you had knowledge that you weren't allowed in the store.
Even if the manager had told me to go back in and had to leave to catch a flight.
If the manager was, you still had knowledge that you weren't supposed to be in the store. It doesn't matter what other people tell you, you have knowledge of what is right and wrong, and you have paperwork. The law enforcement, the law is more than a person. Basically, if you know something's illegal, you shouldn't do it, even though someone else tells you to.
And how would I be expected to return back to the property I was trespassed from? I wasn't allowed to leave with my belongings.
No one ever told you you weren't allowed to leave the property.
Well, we do have a constitution,
I was out of gas
and it is
and I
hilarious.
was told to leave the property. Apparently, I was making Jessica uncomfortable. I suppose that brings me to another great question. If I was waiting for her to leave so that I could purchase gas, so that I could go, because she denied me the sale of gas, would that
He's waiting for
change anything?
waiting for a shift
Okay.
change.
No, because there are other gas stations and you shouldn't have gone in the store you were trespassed from. There are other gas stations you can go and buy gas from. You don't have to buy it from that gas station. If you are, and we also have gas cans that we can provide people gas if they ask us and let us know, hey, I'm out of gas. But
So then how would one in law enforcement expect me to leave and come back to a property that I was trespassed and still follow the RCW or Lacey Municipal Code that we're operating here today?
yeah, because you were advised that you could stay by your car and you had the allowance to stay at the car until the evening, until you had moved the car to the other side of the gravel lot, which wasn't the 7-Eleven property. About 25 yards away, there's a little gravel space. And then if you would have manually pushed, like you offered, push it over off the property, and then you could walk to another gas station to collect gas as well.
Thank you. Thank you, Evers.
Mr. Miller?
Okay.
Okay, Mr. Sharp,
think
any
that'll
further
be the last
questions?
I do have a couple of clarifying questions, Your Honor.
Thank you.
So Officer Evers, Mr. Milton, I think, was asking about how you conduct investigations like this one. You had mentioned that you work to develop probable cause. And I think
Yes.
you explained what that means.
Yes. So basically, when we develop probable cause for a crime, it's basically if you think about it in a plain way, like evidence. So if I have evidence that someone had committed a crime, then I can make an arrest based on that evidence. So I had the evidence of that I had given him the warning, that staff had advised me that he had been in the store twice, and that I had also advised him that he wasn't allowed back in the store. That was my probable cause.
So how did you get this evidence?
Of the evidence that I had the form that I had given him, I had the copy of the evidence as well as witnesses, Miss Heasley, my personal observations of his behavior when I was contacting him, that he was intoxicated. I confirmed basically what she was saying. He was intoxicated. He had been belligerent inside the store based on her testimony. It was a bit argumentative with me as well. And then my physical evidence that I had trespassed him.
And Mr. Milton asked you about a truck stop that was across the street by, sounds like it was a tribe.
Mhm.
And I believe your answer to Mr. Milton was that no, you weren't aware that permission to do that truck stop across the street. Given that that is a separate property than the one we're involved with here, does that make any difference? Would that have made any difference in the investigation?
No.
Mr. Milton had asked you a couple of questions about his ability to leave, and your answer that he had suggested he push his car to that gravel lot, and you had granted him the leeway to do that. And you had suggested that gas could be bought at other gas stations. Are there other gas stations reasonably nearby?
Yes, yeah, within walking distance, there's a Chevron. If you cross, there's a little bridge on I-5 on Marvin Road. I'm not sure the distance. I would approximately less than 2 miles at the most, 2 miles.
Say that's reasonable.
Yeah. Yeah.
Questions, John?
Thank you, Mr. Sharp. Mr. Milton, any further questions for Officer Evers?
No, Your Honor.
All right, thank you. Members of the jury, any questions for Officer Evers? I see one, Teresa. You'll go get the question.
Oh, good Lord.
I
We're
see
having
two.
a question from the juror.
Okay. No, that's fine. You'll hand Teresa your written questions, please.
I agree.
Just, Teresa, just tear off a piece of paper with the question. And thank you.
Yeah, she was a piece of work.
Teresa, thank you. If while you're there, if you'll just have the jurors step back into the deliberation room, please. All rise. Please be seated.
And Your Honor, I'm going to retrieve exhibit 1 for the clerk. It's long.
Thank you. Actually, 3 questions here. First question is, why could not Mr. Heasley's friend drive the vehicle away?
Oh, Jesus.
Mr. Sharp, any objection to that question being proposed to Officer Evers?
The one hang up the city has there is the name. I suppose officer would have an opportunity to correct that. No objection.
Well, I mean, there's no name in here. It just says why. It just says,
Your Honor said Mr. Heasley.
okay, I'm sorry. The question was why could not the friend drive the vehicle
Okay,
away?
no objection.
Okay, and Mr. Milton, any objection to that question?
Negative.
Okay, I'll ask that. Next question is, how did Officer Evers know Mr. Milton? I'm not going to ask this question because it has the potential of being prejudicial to Mr. Milton, potentially. So,
Already answered all of it.
okay, so I don't intend to ask that question. There has been some evidence provided, but I don't need Mr. or Officer Evers to go into a history of why she may have had previous contact with Mr. Milton. I don't want that influencing the jury's verdict.
Understood.
Okay. And then the third question was the Forerunner Mr. Milton's vehicle or Ms. Heasley's vehicle? Any objection, Mr. Sharp?
No, Your
That
Honor.
question. Mr. Milton, any objection if that question is asked?
No, Your Honor.
Okay, so I will ask two of the three questions.
Wow. Thank you. Oh, good Lord. We've got a jury that might mess this up.
Please be seated.
None of these questions are relevant, but okay.
Folks, you submitted three questions. I've reviewed the questions with Mr. Milton and Mr. Sharp, and I'm going to ask two of the three questions. Officer Evers, do you have, or I guess, what is your understanding as to who the Forerunner belonged to, Mr. Milton or Ms. Heasley?
Is registered in Mr. Milton's name when I ran the play.
Thank you. Mr. Sharp, any follow-up to that question?
No, Your Honor. Thank you.
Mr. Milton, any follow-up to that question?
Thank you.
And the next question, Officer Evers, is why, to your understanding, did the friend not drive the vehicle away?
I didn't really have any. He was sitting in the passenger side of the car. I didn't really interact with him. I let that, since it was Mr. Milton's car, I let them decide that between them. I didn't know if he had been drinking with them. I don't have any information of that. So I left that up to Mr. Milton to have his responsibility of getting the car off of the property.
Thank you. Mr. Sharp, any follow-up to that question?
Cute. The microphone must be off.
Yes.
Thank you. Mr. Milton, any follow-up to that?
No, I don't, I don't believe that anything further that I can ask will assist my case any more than just putting on a bit of a show.
Okay, thank you. All right, Officer Evers, thank you for your testimony.
Thank you, Your Honor.
Mr. Sharp, any further testimony?
No, Your Honor, and the city at this time would rest.
All right, thank you. And Mr. Evers, do you wish to testify today?
No, Your Honor, but
Okay, actually, tell you what, let's pull off on
I
that
heard you
thought.
just call me Mr. Evers.
Well, that won't work. Mr. Milton, do you wish to testify?
I appreciate you. She'd probably make a great wife.
Do you wish to testify, Mr. Milton?
I would, but
Actually, hold on. We'll have
yeah,
that
right.
conversation.
You already know what I'm gonna say.
Folks, if you want to step back into the deliberation room, I'm going to discuss Mr. Milton's right to testify with him.
May I ask the jury a question first?
No.
All right.
All right, so, shuts. So, Mr. Milton, I know this is, and we talked yesterday about this is going to be confusing where you're acting in one time as your lawyer and another time as you as the defendant in a criminal charge.
Right.
So it's the testimony part where you get to tell the jury what you believe the facts are. And if you don't testify, the facts are going to be not in the form of what you say when you're asking a question. It's going to be the responses that you got and that the jury has heard. So if you're satisfied that the information has come out, that's fine. If you want the chance to say something different to the jury, it comes with me putting you under oath, you asking questions, and then Mr. Sharp can cross-examine you once you just telling the jury. I'm not going to make you ask yourself questions. You telling the jury what you believe you want to say to them by way of facts, and then Mr. Sharp would have an opportunity to cross-examine you.
Right.
And then I would give the jury a chance to ask you questions if they had any.
Right. My only concern is the concern that I brought up yesterday, which I won't digress and repeat.
Okay. So the answer then is you're choosing not to testify.
If Mr. Sharp would like to call me to the stand and ask me some questions, I would allow it, but
Okay.
I will rest my case
Okay.
as I am.
That's
Thank
the
you,
exact
Your Honor.
language that would be used. Okay. So there will be no further testimony. The jury has taken a break, so now would be a good time for us to review the closing instructions. And I started that process yesterday after we concluded. Mr. Sharp, what we are going to need is the instruction on the defendant, in this case, Mr. Milton, not testifying.
Yes, sir. I'll prepare that and email it to the clerk.
Thank you.
Hopefully she can
So-
print it out so Mr. Milton can see it.
The reason I'm saying that, Mr. Milton, is there's an actual instruction to the jury that tells them the fact that you've chosen not to testify cannot be held against you. They cannot make any assumption based on your choosing not to testify.
Cool.
So-
Will you also let them know that I allowed the city to call me as a witness if they'd like?
Well, I'm not going to say that, but I'm going to instruct them that they can't hold the fact that you're choosing not to testify.
I appreciate that. Thank you. That's Your Honor.
It's going to take me a few minutes, Your Honor, to prepare that.
I understand it. And once again, we're going to be a few minutes. Teresa, you don't have to wait there. We're going to actually go to the instructions. So tell them it'll be a few minutes. Just as a reminder from yesterday, what I'm looking at here are the instructions on the law, and I know Mr. Sharp provided you a copy yesterday. So I just want to make sure you understand that that's all I'm looking at.
I appreciate that, Your Honor. Thank you.
Your Honor, this is a very brief instruction. The model is
It is.
6.31. If it's okay with the court, I'm going to send it to the clerk without citation.
Okay. Thank you. Teresa, you're gonna get a copy of an instruction if you'll print it up for me.
I don't think they think they can
Rob
win.
is gonna email it to you. City rested and Mr. Milton rested.
Yeah, I'm ready. I already prepped my witness. I might pause this and change clothes. Now that you mention it.
End of this. No.
It'll be added in.
Well, I mean, just I'll leave it running, but it's a good point. I really should get myself ready.
Have to feel like I should be elected emperor of the world before I could be that arrogant, not show up for a sentencing. Like really, like top two. Only me and one other person get to run for emperor of the world.
It's not in the outbox. It's already gone. I can send it again. I also have a thumb drive in my briefcase that I could put it on to walk it up to you. I'll do that.
State your name for the record, ma'am. Nut. Okay, thank you.
He was dry humping all that, dude.
Oh my God.
Yeah, that's what I was saying. He was getting after it when I pulled up.
Why don't you send it to, who should he send it to? Who would then send it to?
Okay.
And then have Candace send it directly to you.
Let me make sure I'm connected. Oh yeah, I'm connected to the internet because I got the instruction to come up.
Swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
I suppose.
Did you think so?
Y'all out there bunny hopping and I'm out here dealing with a naked man humping the ground.
The proposed instructions. Instruction number 1 will be the 3-page opening instruction. Instruction number 2 is the reasonable doubt instruction. Instruction number 3 is the direct or circumstantial instruction. Instruction number 4 is the to convict instruction. Instruction number 5 is the definition of knowledge. Instruction number 6 is the voluntary intoxication instruction. Instruction number 7 is the instruction concerning Mr. Milton not being required to testify. Instruction number 8 is the duty of the jurors instruction, and number 9 is the closing instruction. The verdict form appears to be in proper order. Mr. Sharp, any objection to those instructions being the instructions of the court?
Just an inquiry, Your Honor. So, Your Honor, I believe the court assigned instruction 4 to the to convict instruction.
Yes, I take out your
took it out?
definition of criminal trespass.
Okay, no objection. Thank you.
Thank you, Mr. Milton. Any objection to those instructions?
I wouldn't know what to object, Your Honor. Thank you.
You're welcome. All right, those will be the court's instructions on the law.
Yeah.
And we will make copies for each of the parties and for our jurors. For the jurors, make 7 copies for the all.
No objection, Judge. I'm still a big clueless dummy.
Actually, you'll need the cover. Sorry.
That's not very lucky.
Can you guys hear me? Because it looks like I've lost the feed. That's my question. Hello. This is Attorney Mike Gravel coming to you from Chicago as usual, and we may be reaching the end. I don't even know. I just saw the video drop. I tried to look around, but I can't really figure out what's going on. It did appear to. I don't know what's going on. I don't know what happened here. I'm sure that's fascinating and all, but I wanted to stream it. I just lost it. I lost it. Liz, I don't know. I don't know. We'd have to evaluate you. Let me go back and see if I can find it. I don't know. Oh, wait. Seems to be back. Hello. This is Attorney Mike Gravel coming to you from Chicago as you.
Instruction number 4 is the to convict instruction.
Okay. The feed is gone. It's a group trip. I don't know how that happened. It definitely got worse. Oh, come on. I want the gripping finale to this, slushy caper. I really do. Slushy Gate, as it came to be known in the chat. Thank you, Kimberly. That's more than I deserve. That's way more than I deserve. Ask anyone who really knows me. Oh. Well, you know how it is. You know how it is for us old guys. It's not so easy. All right. Let me see if they've gotten it back together over there. All right. Forget that. We're just going to do this. I'm ready for all contingencies.
SM.
This is also Natalie D's fault.
Press roster on behalf of Mr. Snyder for the purpose of arraignment.
If that comes back on, let me know.
Mr. Snyder, can you hear us?
Yes, I can.
Very
Sure.
good. State your name for the record.
My name is Damian J. Schneider.
Very good. Ms. Strasser.
Mr. Snyder intends to plead guilty to disturbing the peace this morning.
Sir, you understand if you plead guilty, I have to take the plea as it is currently written. I cannot change it. I cannot modify it in any way. In order to do that, that would be something you'd have to cover with the prosecuting attorney. You understand that?
No problem. Can I, sir? Yeah, I am guilty to that charge. But there's a lot of things that
Right, so
lead
let
up to
me,
that.
before we go on, then I need to make sure I have a basis for the plea, and then I'll let you have then you can say other things. But
Thank
first, sir, you understand you have a right to a trial, and if you went to trial, the prosecutor would be obligated to prove that you're guilty beyond a reasonable doubt.
Yes, sir.
You understand that if you make a plea here today, you're going to tell us you're guilty, and there's not going to be a trial of any kind. Is that your intention?
Yes, I am guilty of that charge.
Has anyone tried to frighten you or force you or intimidate you into doing this?
Absolutely no.
Has anyone made any promises to you that I'm not aware of?
No.
Are you currently on probation or parole for any other criminal convictions?
No, sir.
And are you a citizen of the United States?
Yes, sir.
The allegation here indicates this is an incident that occurred on July 10, 2023. Is that true?
Absolutely. I'm not aware of the date. It was really dark. So, on about, yes.
It's an incident that occurred in the city of Allegan, county of Allegan, state of Michigan. Is that correct?
Sometime.
In the city. It was at the courthouse.
Okay. And at that time, did you become involved or create a disturbance that necessitated law enforcement response?
Absolutely. I was doing donuts and wrongly, unbehaving behavior on my behalf, and I'm so sorry, sir.
All right, very good. Are you satisfied, Ms. Strasser?
I am, Your Honor.
Very good. Other than fines,
That's unbehaving behavior. Another Law Talk with Mike t-shirt potential.
costs, Ms. Strasser?
We asked the court for fines and costs in this matter.
All right. Sir, fines, you've provided me with a basis to accept the plea. I will do so. Fines are $200. State costs $50. Court costs $200. Crime victim right fee of $75. That's a total of $525, and I'm going to give you 90 days to take care of that, all right?
All right. Hey, sir. Yeah. Thank you. And then now, can I speak?
Sure.
Oh, he's about to speak, and it doesn't help.
So, hey, Judge. So, listen, I'm going to tell you something. So, I don't know what's going on with this court system, but you got a beautiful district court. Now, we have some issues. I have, so I've been wrongly prosecuted in the circuit court here. And then I had a judge, and this circuit court had, had the PPOs
Okay.
behind my back for a few years, sir. Now, listen,
Okay.
the problem that I have with this court system is the circuit court took everything that I love and they took it away from me. They took my coaching degree from me and they destroyed me. And it's all because other people had control over me. And now I'm upset. They found me incompetent. Now I got to go deal with this stuff. So the reason why I was out there doing all that is out of anger,
Okay.
hatred, and that was wrong of me. I'm going to give it all to the Lord.
Judge, the reason I committed this offense is out of anger and hatred. Okay, that doesn't help in any way. But now he's going to give it all to the Lord. Super. Good idea. Too late. Oh, it's too much.
I'm going to give it all to the Lord and submit everything to the Lord. And what I appreciate you being honest, and I love you guys.
All right. Well, I'm sorry you're going through those other difficulties. I don't have any jurisdiction or ability to address those, but it sounds like you've settled on a course of action to bring yourself some serenity. So good luck to you in that, and you can leave the court. Good luck to you, sir.
Yeah, thank you, sir. And I appreciate your honesty. It goes a far way in the community. And we look up to people like you that makes a difference in people's lives. Bless your heart.
Thank you, sir. I appreciate that. You're all set. You can leave the court, all right?
Thank you. And have a beautiful day.
You too. All right.
All right. Thank you for that pile of crazy. And speaking of crazy, I've got some crazy for you. I got some crazy for you. Let's try this for crazy. Courtesy of Kristen.
This Huey was the probation violation with 5/30/2023. That's the probation violation that I have. And that violation was FTA, failure to appear and admitted to see the she's using that. Later on yesterday, I got a bond violation notice after I spoke about a benchmark unable to produce an FTA and failed to appear for PSI. I got that yesterday.
I have not seen this, so I have absolutely no idea if anything happens. But she does have a tendency towards the dramatic. I
was also informed by Alicia, maybe in here. Oh, she has new charges of attempted police officer.
Right.
Sydney. If that's going to be part of the revocation, well, I don't know about revocation. She may be amenable to that. However, if there are new charges in a probation violation, typically I don't like to go forward with the probation violation because she doesn't have many rights in that probation violation and as many rights as she would in the primary charge. So what I'd ask the court to consider is delaying the probation violation while the primary charge is being sorted out.
Yeah, and that'd be fine, but she's gonna have to stay where she is. And let me ask Ms. Helmrich if she's okay with adjourning. Ms. Helmrich, are you okay with adjourning this proceeding with regard to Ms. Hewitt until her felony is worked out one way or the other?
I'm fine with it. That's up to you, Judge.
I'm not guilty until proven guilty, so that's kind of unfair. I didn't get to hear the whole first part. It was muted. It wasn't unmuted, so I don't even know what was said. And I was in treatment when I was violated, when we missed our, when you first violated me. Actually, all 3 violations. I was in treatment and sober living, so I don't understand why I got violated. Like, I can't just pick up the phone when I'm in treatment and call you. You were made aware that I was in treatment.
So, okay, hang on, Ms. Huey. If we adjourn, then Mr. Settles will have more of a chance here to speak with you about those defenses.
No, but I only got to go to treatment for 2 weeks and then to sober living. I'd like to go back to treatment. I was trying to talk to Sarah. They only funded me for 2 weeks because it's only my 2nd time in my whole life going to residential treatment. So
Okay,
this time I would get funded for long.
Ma'am, Ms. Huey.
Yes.
Please, when I ask you to stop, stop. Otherwise, I'll mute you. Your attorney wants to say something. So, Mr. Settles.
I apologize.
Ms. Hughes, after you and I spoke yesterday, I received another notice of violations that you and I had not spoken about. You and I talked about your failure to appear violation and your admission to CMH, which I know from talking with you, we were going to have a hearing on that because you were in fact unavailable on that May 5th, 28th, number one. And number two, you didn't admit to anybody you're taking meth because you weren't taking meth. That's what you and I talked about yesterday. After you and I stopped talking, I got another violation that says that you were unable to produce and you failed to appear on some other dates. And that's not so important to me, but what is important to me, it notifies me that you have new charges, that you are now, the prosecutor is going to file new charges against you. They have already filed charges of attempted police officers assault, RNO. So that also would be the basis for a probation violation in this case. And since that's true, you have very few rights in a probation violation. Whereas as a defendant in the RNO case, you have lots of rights as a defendant. Therefore, it has been my practice not to have hearings in the probation violation where you don't have many rights and the rights of the Michigan rules of evidence are loosely applied. I would prefer that the new charge matter, where you have lots of rights, be sorted out and be sorted out together with any prior PVs that are being alleged. Do you understand?
Yes, I do understand now. See, I couldn't hear all that, so I apologize.
I understood that you came in late. So right now, this would not be a good time to have a hearing on those two things that we talked about when there's other things out there. And it would not be a good idea to have a hearing on R&O because there's going to be lots of evidence that you and your attorney are going to have to sort through. Thank you very much.
All right.
So I believe that Ms. Hughes, she is in agreement to adjourn this hearing, aren't you?
Till when?
No, you're not?
No, I would like to get this all done. I would just sentence me to everything and just get it done at this point. I can't keep doing this. My life has been held up so completely for the last 2 years. Like I want to go to treatment or just sentence me to whatever time you're going to sentence me on all of it, and let's be done with it. I've already.
Ms. Huey,
Yes.
I think it would be better to follow Mr. Settle's advice. That makes sense. All right, because even if you had the hearing today and you were found responsible, the recommendation is for a medium or long jail sentence. So, that's what would happen. Okay. So it makes sense to wait. You're in jail anyway. Wait till Mr. Settles sorts out the new case. So let's do that. Let's adjourn. We'll adjourn. We'll continue the judgment. And probation will reset this. By now it's attempted R&O. So, and retail fraud second. So that must be set for a pretrial coming right up here. Is that right?
Yes, the pretrial set for August 17th.
All right. So,
So you got a pretrial, you'll have an attorney in your other case, your other attorney will sort out that case, keep in contact with me.
Can I get your information so I have it? So, because I have nothing here to write anything down or anything. Can you make sure I have your information as my attorney on the probation violations? And then,
it's in the mail.
well, to the jail though, right now?
Yes.
Oh, thank you. I appreciate you so much. And then, Judge Stepka, if we could, when all this is all sorted out, I would like to continue treatment and go back to my sober living. So I know who I need to talk to about that. But
sure.
I
So that,
appreciate
yeah,
your time.
we can talk about that and consider that. So for now, we'll adjourn, and maybe we can ask probation to set this on the same date as the pretrial conference. I don't know if it'll be resolved, the pretrial case, but we can try.
Okay.
So that's what we'll do. And you probably don't represent Ms. Huey in the misdemeanor. Okay.
I'll see if we can get the other guy. Maybe.
Yeah, that would be wonderful.
Up to
If
speed.
that's that would be wonderful. Thank you so much. And Christy, it's finally nice to meet you.
Okay. So we're all set, Ms. Huey. So thank you, and we'll see you, on the 17th. Thank you.
On the 7th.
10:30. Okay, very good. Thank you very much.
Thank you, Mr. Settles. You have a prelim too, don't you?
Yes.
Wow. Well, she got through that. Maybe she is getting better. I mean, not great, but better. There was no freak out there. No freak out. No finish to the trial. Let me check one more time and see if they got something going on over there.
And the one exhibit that has been admitted during trial. If evidence was not admitted or was stricken from the record, then you are not, unless they have been admitted into evidence, you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during deliberations about the reasons for my rulings on the evidence. If I've ruled that any evidence is inadmissible, or if I've asked you to disregard any evidence, then you must not discuss that evidence during deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that has been admitted that relates to the proposition. Each party is entitled to the benefit of all the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things he or she testifies about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The attorney's remarks, statements, and arguments are intended to help you understand the evidence and to apply the law. It is important, however, for you to remember that those statements are not evidence. The evidence is the testimony and the exhibit. The law is contained in these instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence or the law as stated in these instructions. You may have heard objections during trial. Each party has the right to object to questions asked by another and may have a duty to do so. These objections should not influence you. Do not make any assumption or draw any conclusion based on an objection. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express, by words or conduct, my personal opinion about the value of testimony or other evidence. I've not intentionally done this. If it appeared to you that I have indicated in any way my personal opinion, either during trial or giving these instructions, you must disregard that entirely. You have nothing whatever to do with any punishment that may be imposed in case of a violation of law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the parties may properly discuss specific instructions. During deliberations, you must consider the instructions as a whole. As jurors, you are officers of the court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. The defendant has entered a plea of not guilty. That plea puts in issue every element of the crime charged. The city is the plaintiff and has the burden of proving each element of the crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists. The defendant is presumed innocent. This presumption continues throughout the entire trial, unless during your deliberations you find that it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists. It may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If, after such consideration, you have an abiding belief in the truth of the charge, then you are satisfied beyond a reasonable doubt. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in the case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in the case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. To convict the defendant of the crime of criminal trespass in the first degree, each of the following elements of the crime must be proved beyond a reasonable doubt. 1, that on or about March 31st, 2023, the defendant knowingly entered or remained in a building. 2, that the defendant knew that the entry or remaining was unlawful. And 3, that this act occurred in the city of Lacey. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if, after weighing all of the evidence, you have a reasonable doubt as to any of these elements, then it will be your duty to return a verdict of not guilty. A person knows or acts knowingly or with knowledge with respect to a fact or circumstance when he or she is aware of that fact or circumstance. It is not necessary that the person know that the fact or circumstance is defined by law as being unlawful or an element of a crime. If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted, but not required, to find that he or she acted with knowledge of that fact. No act committed by a person while in a state of voluntary intoxication is less criminal by reason of that condition. However, in determining whether the defendant acted with knowledge, evidence of intoxication may be considered. The defendant is not required to testify. You may not use the fact that the defendant has not testified to infer guilt or to prejudice him in any way. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors, nor should you change your mind just for the purpose of reaching a verdict. When you begin deliberations, you should first select one of you to act as presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 6 of you are present. You are all officers of the court and must evaluate the evidence with an open mind, free of bias or prejudice. If during deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During deliberations, you may discuss any notes that you've taken during trial, if you wish. You've been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during deliberations. If, after carefully reviewing the evidence in these instructions, you feel a need to ask the court a legal or procedural question that you have been unable to answer, write the question out, pardon me, simply and clearly. In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to Teresa. I will confer with the parties to determine what response, if any, can be given. You'll be given the one exhibit admitted into evidence, these instructions which you have, and a verdict form for recording your verdict. Some exhibits and visual aids may have been used in court, but will not go with you to the jury room. The exhibit that has been admitted into evidence will be available to you in the jury room. You must fill in the blank provided in the verdict form, the words "not guilty" or the word "guilty," according to the decision you reach. Since this is a criminal case, all 6 of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict form to express your decision. The presiding juror must sign the verdict form and notify the clerk. You will then be conducted into court to declare your verdict. Mr. Sharp, how much time do you wish to reserve on your closing argument?
2 minutes, Your Honor.
Okay, thank you. Mr. Sharp.
Thank you, Your Honor.
the whole thing. This is a pretty important process. Title to this day in court. It's had that happen. That didn't happen if you weren't here. This was important because of the property laws. So, issue, otherwise on criminal way. So this is not only important just for Mr. Memphis, as well as 7-Eleven too. So all this together, it's not going to be in a movie, but it's still pretty important. So as I described this morning, you heard from 2 witnesses, and they both testified about 2 phases. That's how I'm kind of bundling things here. But there was the earlier afternoon incident 7-Eleven about 2 o'clock when police were first called, and then the second incident later on, 4:30. The purpose of having both of those phases explained to you is that the first event really sort of sets the context. The city not accusing Mr. Milton of trespass within that. The first one was he was notified.
Yeah, I can't hear it either, but he has crossed his 2-minute threshold.
What term does speak a lot with this is elements. These are the elements that the city must approve. 1, 2, 3. It's a little different than the order that I just gave, but it's the same material. And the city has the burden of proving each of these beyond a reasonable doubt. I embrace that burden. It's important that it be hard to prove the crime. Evidence needs to be substantial. This case is pretty clear. They'll submit that there's not a reasonable doubt. So I'll just really quick kind of review what facts pertain to each of the elements from what you heard this morning. So the first one that on March 31st of 2023, stop there. You heard 2 witnesses ask about what happened on that particular day, and then they relayed the information that was, so it's pretty clearly established, and no reason to doubt this. Next, the defendant knowingly entered or remained in the building. Here, he's accused of entering that building. Specifically, it's that second. It's after the police left. After he did not know. So he's alleging that he knowingly entered the building. We heard from this testifying that he came back in. He again brought a cell phone with him, putting it up on the counter. That he, at that point, was again basically conducting himself in the same way, shouting, some customary about a confrontation with an elderly gentleman that was in there, and that got pretty contentious. You heard about him throwing a fit, sitting on the floor, refusing to leave the store as asked, forcing him to basically call the police again to intervene. Second element, the defendant, Mr. Milton, knew that the entry or remain was on. How could he not told by Ms. Inslee at the beginning when she started reasonably with him? Okay, you believe that's not, you can't swear at me.
This is how they start.
Also, Evers testified that she made it very clear to him not to go back in that store. He not only told him, she gave him written instructions about that. You're going to have a chance to read this form in its entirety. It makes it plain as day. He's not to go there, and if he does, there's a specific law that violates. as Officer Evers mentioned, she wrote acknowledged in the sign. I want to point this out because I could see it being signed. She explained why she did that. Because of his behavior, and she has to be concerned about personal safety.
Oh, thank you.
Someone that could be used as a weapon. There is aggressive behavior happening, unpredictability, intoxication. So this is a procedural thing. You know what? I'm going to tell you that didn't matter. Let's look back again at the instruction floor. Number 2, the defendant knew that the injury forming was unlawful. Is there anything in there about a form? So I don't see anything saying that the city was required to give Mr. Milton a form, Mr. Milton was required to sign a form, or anything like that. We just have to prove that he knew that entering that store was unlawful. Okay. Now this form, this sure is a nice tool, right? This makes it very clear to Mr. Milton what the expectations and parameters of the behavior were, what the potential consequences of going outside of those parameters would be. And it also makes it very clear to others like us that he was aware of what the situation is, and that wasn't going to be acceptable. So I suggest taking this form as a beneficial tool, keeping in mind that it's not actually required. It's not in that jury instruction. It has to be a form involved at all. Finally, and this one's kind of a no-brainer, but this act occurred in the city of Lacey. We heard Jessica Easley testifying that she worked at the 7-Eleven in Lacey. We heard Officer Evers testifying that she controls the police department for the city of Lacey. She was responding off to that logical. Ask you again to flip some pages here and go to instruction 2. I had mentioned that the city has the burden of proving these elements beyond a reasonable doubt. I embrace that burden and we think it's been reached. This is the instruction that explains what that means. You heard the judge explain it a minute ago, so I'm not going to belabor the whole thing. I just wanted to really hone in on that 3rd paragraph. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. So there's a reason, there's a foundation for it. There's some sort of cause for that doubt that's logical and that arises from the evidence or the lack of evidence. We're working within the parameters of this evidence. I think during jury selection, Drew was talking quite a bit about how that happened for her in the trial. We get one of the things, so I appreciate that. I think in advance for working within the evidence. I want to address really quick the intoxication. There is an instruction in here. I think it's number 6, and it's a pretty brief one. No act committed by a person while in a state of voluntary intoxication is less criminal by reason of that condition. I would invite you to agree with me on this. I read that as saying, you don't get a freebie just because you got them. You don't get to go consume alcohol and have a license to do whatever you want, treat people however you want. It doesn't work. There's a second sentence here that's important today. However, in determining whether the defendant acted with knowledge, evidence of intoxication may be considered. That's super important because knowledge is at the core of this case, right? Did you know who's going in that building? Did you know who was supposed to go in that building? I want to really zero in on this and submit to you respectfully that certainly knew what. Not so drunk that he didn't. Officer Evers explaining her background, her formal training, and then her experience on the street dealing with people in various levels of intoxication. She had specific signs to look for and ways to gauge that work. She explained to you that she observed Mr. Milton getting out of the vehicle, standing on his own 2 feet without assistance. He was able to walk over to the police car to get into that without any help. She recounted for you a fairly complex conversation Now, while he did repeatedly assert that he was too drunk to be held accountable, she did mention that when he had an idea to discuss, there was a productive dialogue. She didn't give any indication that there was any sort of confusion or inability to understand on his part when they were having that conversation. I mean, think about that whole thing with troubleshooting the car. He's not allowed to be at 7-Eleven, but his car is there. Can't drive it. What do we do about it? As she explained, Mr. Miller came up with the idea. Hey, how about if my friend and I push it about 25 yards off the premises to the next lot over? First of all, I want to point out, it wasn't Officer he was just being super reasonable about that. Yes, of course, that makes sense. I'll give you some time to figure that out. Okay. But what that's really showing us here is that Mr. Milton did have the clarity of mind to work through the sort of processes that would allow him knowledge of his restriction for doing that. He demonstrated logical thinking, right? And with a problem, he on his own offered a solution, negotiated that with the officer. Is that a person that's too drunk to know what's going on? That's not the time. That conversation, with him understanding that his vehicle needed to be somewhere else, that implied an understanding of his ground. Implied he knew he couldn't have his vehicle there forever, or there would be some sort of consequence, right? That's the same thought process involved in knowing that he couldn't go in the store. He knew that there was a parameter, a limit, and if past that limit, there won't be some sort of consequence. So all this together, I would submit to you that while he repeatedly told the officer that he was too drunk to be held accountable, suppose I'd ask you, was he too drunk to be held accountable? Is that a thing? When cherry on top of this argument, a person that immediately on the scene repeatedly would say, I'm too drunk to be held accountable. Is a person that's too drunk to be held accountable able to say, I'm too drunk to be held accountable? Wouldn't a person too drunk to be held accountable be too drunk to be able to say that, to formulate a complex thing like that? That's a question for you to answer that.
Mr. Sharp, you are entering your reserve time.
Thank you. Ladies and gentlemen, close of arguments here. I'm going to go back and I wish you luck in your deliberations.
Thank you, Mr. Sharp. Mr. Milton.
Oh, good Lord. Too long-winded. Come on, Big Lebowski. Let's see. See what you got. I don't know if he's talking or not. I can't hear it, but I know it's stupid.
Assistant manager, I believe. Start to go, get my gas. Definitely.
Your Honor, objection. Again, I'm so sorry to interrupt, but Mr. Milton is introducing evidence. In other words, testifying while he's not under oath.
All right. Thank you. Jury's to.
Oh, are you not under oath?
Okay, hold on, Mr. Milton. Jury's been previously instructed to consider the facts only as provided through testimony.
I'm not a witness. I'm not allowed to testify as a witness, and I'm not an exhibit.
Your Honor, objection. That's a misstatement.
All right. I'll let Mr. Milton go ahead.
Appreciate you. I digress. Phone was not mine. It has been asserted this entire time that it was. For whatever reason, that seems imperative. I was instructed by the management at the time, we did not have time to stick around. Selling anything, specifically, you're right. That I don't speak with Jessica and get. I guess I'll close with, if I was one of your children, would you feel like the police did a good job or a bad job in this case? Finding me guilty or not guilty?
Thank you, Mr. Melton. And Mr. Sharp, you have 2 minutes left in your.
If I was one of your children, it's an improper argument, but who cares?
Your Honor, as a procedural matter, I suppose the city would move for clarification for the jury on. Mr. Milton asserted that he didn't have an opportunity to testify.
Which he did, but chose not to.
May I, Your Honor?
No, we don't need to get into any more than
Okay, sure. I merely wanted to ask if they were presented with the same concern that I had yesterday.
that. Jury's only heard what they've heard today.
Gotcha. Appreciate you.
Sure.
Gotcha. Appreciate you.
So, ladies and gentlemen, touch on indication.
Give him the hook, Judge. I gotta go. Yesenia is Mexican.
Not under oath, Dan.
He's not. Thank you.
Thank you, Your Honor. I will take.
No.
Oh,
City always goes last because they have the burden of proof. You don't have to prove anything.
oh. Okay.
It's
Okay.
over.
Folks,
You-
you've now heard closing
Talk-
arguments. You're going to retire to the deliberation room. You're going to select one of you to act as presiding juror and then deliberate on your verdict. When you've reached a verdict, you'll just notify Teresa and we'll bring you back into court to declare your verdict. Juror number 7, this is the point where you separate from your colleagues. You can just stay right where you are. We're going to send the other 6 back and then I'll have a short conversation with you. Okay, folks, if you'll.
Do you have any questions?
No, at this point, we're done with any fact gathering. Please be seated. Here, number 17, it's always a little awkward, you know, we ask you to give us all your time and then you don't get to stay to conclude as your service as a juror. So.
All right. Well, we got through the whole trial. It should be a guilty verdict. I don't know that it will be, but based on the dopey question from the one juror, they should be back in a few minutes, but I don't have time to wait around, unfortunately. I thought about just leaving it running, but I can't. I can't just leave an open stream. I'm going. I'm going downtown. I can't do that. If I had someone to step in and just hang out for, I'm guessing this probably in the next half hour we come back with a guilty verdict. Would be my guess. He was guilty as homemade sin. There's no two ways about it. His instead of running his mouth, he was funny in that he just emoted some, like, you know, He just dropped some emotions and then refused to do anything for voir dire, for cross examination, for everything. He just wanted to express his feels and not ask questions. It was pretty funny. All right, but I really do have a hearing to get to, or that is actually important. Thank y'all for coming out. I appreciate it. If something fun happens with the verdict, then I'll show that too later. But I just can't hang out for it right now. I will see you all soon.